Hi, I'm Jake Fry. I'm the owner of Smallworks, and we're a company in Vancouver that specializes in ADUs, coach houses, and laneway home production. And we design and build these homes mostly for families. And what we've found over the years in the hundreds of homes that we've built is it's really important to have a good legal agreement between people so that these projects can be really successful. And when families turn to us, we turn to Ronan Reinhart from Bell Alliance. It's a firm that specializes in this, and Ronan's always been very talented in dealing with these very complicated dynamics that help to make these successful projects. And Ronan, maybe you could tell us a little bit about your work over the last few years.
Sure. Thanks for having me, Jake. I'm Ronan Reinhart. I'm a senior lawyer with Bell Alliance LLP in Vancouver. And my practice, I've been practicing for a little over 20 years now, and in that time, I've practiced in litigation and in business law. And in all of these, I've been working around groups of folks that come together around some kind of a valuable asset, and they have to manage their relationships around that asset, and also resolve disputes around that. And so I bring that experience to co-ownership agreements and helping individuals collectively own real estate in British Columbia. So I'm thrilled to share some of that background and some of the experience here with you and your audience today.
It's great. Well, and we really appreciate it. I mean, it's such a topical and growing sector. I mean, how has that been reflected in your firm? Have you seen this become more and more prevalent form of housing, and maybe you can reflect on
Oh
how that
yeah, it's
has.
been it's been huge. Our firm has a very well established real estate team and a real estate practice, and over the last 20 years, we've really seen some changes in the real estate market across the province. And one of those change areas is in densification, right? Very recently, we've seen the enactment of Bill 44, and Bill 25. These are provincial statutes that force densification initiatives on municipalities. And so, with that, combined with the demand and also price increases in the province, there's really a related demand for understanding how to collectively own property. And really, in the last 5 years, we've seen a significant upturn in the number of folks who are looking to collectively buy and hold real estate.
And to that end, I guess have you found that is it more prevalent for families to be doing this together as an activity to try and get equity off their property, or is it more groups coming together to collectively own a property and make things affordable because of that type of fractional
Yeah,
ownership?
yeah, both, right? Like with families, there's big interest obviously in looking after next generation interests. So you've got, parents looking to support their kids, both for living accommodations, but also as, a big family asset. So they want to help support the financial health of the next generation. And with property values where they are, it's more and more difficult to do that with single family fee simple parcels. So families looking to take advantage of their property lot values for the benefit of the next generation is a big one. But also those pooled, right? So you get pooled purchases of real estate for among friends that want to get in, and they can't afford the minimum buy-ins on single family lots or single dwellings themselves, and they want some more flexibility beyond what's offered by a normal strata lot. So you've got groups of folks that are looking to invest together in their own living situations, and also groups looking to invest, looking at a alternative to securities to park available cash. And so yeah, I'm seeing all of those. But in my practice, the largest volume that I've been seeing lately have been the family situations. So yeah.
So on that, and again, but this, for my own edification and for others, um, what does estate planning actually mean? Like, what is that devices? I know we're talking about a bit about co-ownership here, but I gather this is kind of under maybe a larger umbrella of estate planning.
When we talk about estate plan, we really mean how you're going to plan for your stuff at a time when you can't make decisions about it. So when you're healthy and doing your thing, you own what you own and you can choose how you're going to manage that stuff. But there will come a time where we're no longer able to make those decisions, either because of we may lose capacity, we may lose interest in some cases, or we may lose our lives, right? And so as we think about what we want to have happen to all of the things that we may own at those critical times, that's all an estate plan. So if you don't think about those things in advance, the law has mechanisms that impose outcomes on your stuff. And in most cases, what the law imposes is not exactly what you might want. So the estate plan is about making sure that it's your decisions that govern, the things that you've accumulated in your life.
And so taking that and then adding this sort of extra one or two homes that may be put in, maybe we can talk about how this, how does that fit into family property and estate planning? And is this something that immediately goes to inheritance, or like how do you tend to, how does that tend to be structured, I guess, in the typical situation where, say, a child's moving onto a parent's property?
Well, a child moving onto a parent's property brings in a number of issues, one of which is how and whether or not ownership is transferred to the child when they move in. So if your kid moves onto your property, are you just letting them live there? In which case, depending on the relationships and the discussions, you might set up a simple tenancy arrangement, or most often there's no formal arrangement at all. But it doesn't really hit the estate plan because you're not transferring ownership or ownership rights just yet. Although you'll want to keep that in mind when thinking about your will, which is one of the most important estate planning documents that we can have. But there might be other opportunities in the sense that a lot of families are interested in conveying some valuable property to their child while everyone's alive. This idea of the kind of living inheritance idea where everybody can share in the joy of the property and the gift. And so if the plan is to formally convey ownership in whole or partially to a child, then that changes your estate plan structure because you've already divested a large portion of what would go into your estate. And so, and then it moves it to your child's estate planning kind of desk, right? Because if you actually convey it over to the child, now they have this interest that they need to manage. It really depends on what the ownership profile is, but it absolutely will have an impact on the estate plan for both parent and child.
What is it for a parent to move onto a kid's property? So the children are sort of middle-aged or older and they have a property, but we have an older parent moving on and maybe they're financing that project. Is that something you would approach a little differently than what I've seen conventionally, which is usually a young couple they've decided that they got a solid tight relationship. They've test driven a golden retriever and now they're going to have some kids, right? And they tend to move on their parent's property is because the parent tends to have the asset. But what happens when that gets reversed?
I think it's a different facet of the same basic issues, right? You're still dealing with what are the rights and interests and obligations of the different family members on and relating to this particular piece of property. With the parents coming back in an aging in place situation, there you might have different controls, you might have different contribution requirements. For example, you might say, okay, you know what, parents, you don't need to contribute to a lot of this, these other ongoing expenses. Maybe we want to protect you from some of those. We want you to enjoy your golden years and just and we're gonna give it back, as it were. Or you might have very well capitalized older folks that are comfortable adding to the payment pool and taking on some other additional expenses, which really help out the management and operation of the property for the kids. So how you manage those would depend on the specifics of the case. And also it would, if you've got the children already owning outright the property and their parents are staying there, you may not have an ownership situation, but you might have a tenancy situation, and you might want written guarantees so that the parents have some assurances that they can depend on the relationship and the accommodation going forward. Obviously, a lot of unexpected things can happen in relationships, for example, like you can have family breakdowns, and in the context of maybe a child that has a relationship and they're living on the property, and then parents living on the property as well. Well, what happens if the relationship between the child and the spouse breaks down, and how does that impact the parents on the property? They may want some assurances from both spouses in that case. So there are some slightly different ways of thinking about things, but there's still the same fundamental pool of problems that you're solving.
I'm imagining you want to be establishing wills for all the parties too.
Absolutely. And the wills and a kind of a co-ownership arrangement, they do go hand in hand, right? I work with co-ownership agreements, and so that's just the main document that governs the people that are going to have an interest in the property, the various co-owners, and that agreement needs to work with the will because it needs to leave certain pathways open for testamentary gifts. So that's just what we call the gift made under the will. And what I mean by that is that often in a co-ownership arrangement, you are going to want to control who comes in. You're going to want fairly strong approval rights for other co-owners to approve transfers, to approve new people coming in. It's most often not a good idea to have a wide open door policy and say, oh yeah, anyone that you want to transfer your interest to, sure, they can come on in and become a co-owner. You'd want to look at them. You'd want to get a sense of financial viability. You'd want to get a sense of potential. You might want to get a sense of character. You might want to get a sense of chemistry. This is an asset that people live and function around and are going to be relying on. So in a lot of cases, you don't want to just let everyone gift or transfer their interests in the property wherever they want. And if your ability to transfer gets restricted under a co-ownership agreement, well, under your will, you can't transfer it anymore. So they have to consider each other, and you got to deal with those things. And so often what we'll do is we'll have certain classifications that are approved in advance under a co-ownership agreement. So we might say, okay, Jake, you can leave your portion of this property. You can gift it to a family member if you want. You can gift it to maybe we know a couple of your closest friends, and we say, oh, and if you want to gift it to these people, that's fine too. But anybody else needs to be pre-approved by the other owners. And so if you then go and you leave, or you try to leave your interest to somebody who's not approved, well, then it gets blocked by the co-ownership agreement, and then your will might not operate the way you want it to. So it's important that those two instruments work together and are set up in ways that don't block each other.
Right. And so it's kind of interesting you're talking about that transition, because I'm also wondering, what are the tax implications like the family should know about? Because it seems to me there's a couple things. There's there might be like an inheritance that would happen as a relationship changes, but maybe there's a co-ownership and one of the parties leaves and then another person comes in. How does things like the principal residence exemption and those sort of tax structures, how does that affect it?
Great point. You always have to be aware of tax issues, right? I should point out I'm not a tax professional. I do lots of work with this, and I've got a good handle on the tax issues, but there might be nuances that are out of my wheelhouse. That being said, the big ticket items around owning real estate revolve around exactly as you identified, the principal residence exemption, and that's an exemption that basically says that generally when you sell a piece of like an asset, you sell a piece of capital property, you pay capital gains tax, which is taxed on rates that are different than your normal income. So what you might get taxed on from your job. And among the capital assets that we can sell, one of the most important and valuable to many of us is our homes. And normally, when you sell your home, you'd get an income, like a tax bill, a capital gains tax bill. But we have an exemption in Canada for our principal residence. And so when we talk about the principal residence exemption, that's what we're referring to. We're referring to your ability to sell your home as a capital asset with no tax payable. And so most of us, when we sell our homes, it's a transparent process, and you don't pay any tax on it. And when you're in a co-ownership situation, you have to be very careful about that because federal courts have held, and the CRA has also recognized that where your portion of your living residence is different than the whole property that's being sold, you may not be entitled to your entire you may not be entitled to an exemption for the whole amount. So for example, if you own, let's say 50% of a property and you only occupy a quarter of the property as your principal residence area, then that extra quarter, that extra 25% that you own that you sell will not be subject to the principal residence exemption. So you'll end up paying tax on it, is the point. So you have to be careful that that proportions of registered ownership match the intended dwelling proportions. But also another thing to keep in mind is there are two other important areas of tax to be concerned about. One is property transfer tax. Whenever we transfer and register transfers of real estate with the Land Title Office, we pay that transfer tax, which is calculated based on the value of the interest being transferred. There are exemptions that are available, and principal residence offers one of those exemptions where there's certain family and interfamily transfers. So in a lot of cases, it will be exempt, but it's something that you need to think about. And then there's also GST, right? Like, and GST would apply to new structures, and this is particularly important for folks who are building laneway houses, because if there's going to be a change of title, like you're going to put somebody new on title as a new owner, and they're also going to take an interest under a laneway house, there might end up being GST payable on that if the transfer is timed in certain ways that they become a recipient of the supply. So all of those heads of tax need to be planned for, thought about carefully, and folks need to be aware if there aren't exemptions available, yeah, they're going to have to budget for an additional head of tax payable at certain times. And if exemptions are available, they're going to need to know what they are so that they can make sure that they qualify properly.
I don't think we could go a lot deeper into the weeds, but it also sounds like everyone has to talk to a lawyer if they're going to do this. And probably you. Like what someone should anticipate the length of time it would take to work through a transaction and this, and then, kind of roughly what it would cost.
Yeah. So on that point, one thing that's important to bear in mind is that these are really important decisions, and they have significant consequences. And these consequences they can have a lot of costs. For example, if unexpected tax consequences, but also unexpected consequences in dealing with, family property issues or dispute resolution and things like that. So it's worth giving these really good time and attention. Typically, like to set up a good co-ownership agreement in full. On the legal side, folks can expect probably somewhere between $4,000 to $7,000. And that takes you through a lot of the planning, the discussion, the analysis, and the drafting. It can be more than that in more complex situations. For example, I've had situations where, as part of a co-ownership situation, we might set up, fancy things like trusts, and we might set up separate corporate vehicles and things like that. Most of the time, those aren't at play. But often that's kind of the ballpark that you might think about. Also, some folks are surprised to hear that it's a good idea for them to have accounting advice or family law advice from separate experts in those areas. And some folks might think that that's overkill or too much, but it's like it's all about making sure that you're protecting the value of this opportunity and this asset for yourself. But I think folks should be ready to spend what they need to get it right, because getting it wrong means they could be looking at unexpected costs of many times that.
Yeah, and I have to say, I mean, as you talk about this, this seems actually quite a reasonable, sort of price range that we're discussing. But you did touch on something about, and it kind of makes you wonder, like when you're working with a lawyer and, and you're looking at these estate plans, what's sort of a must-have and what's a kind of nice to have?
Yeah, see, well, in an estate plan, I mean, the three essential documents for a good estate plan are your will, a power of attorney, and a representation agreement. Related to that is the co-ownership agreement. And when you're asking about what's essential, in a way, like they're kind of all essential. Like they do different things, and they do different things that all help you sleep better at night, right? Like with your will, power of attorney, and rep agreement, well, you know that if something unexpected happens to you, the body of your stuff is going to be okay. It's going to be as you expect it to. It's going to be protected. The co-ownership agreement is specific to one piece of property. It's not a general tool that allows you to manage everything in your portfolio. It's about that one particular property. And it's an essential tool in managing that particular property. And when we're talking about real estate, one of the most important things that the co-ownership agreement does is it gives folks a pathway to manage the property that decreases the chances that they're going to end up at court with a Partition of Property Act application. And so we touched on this earlier, and I think it's worth repeating. They work together, and I think they're kind of all essential, although they do address different pieces of your life. Now, I'll close with the thought that if you're looking at buying a particular property right now with other people, and you haven't yet considered your full estate planning package, the priority I would say is your co-ownership agreement, because that's a live current issue that you're dealing with, and you should have a good guidebook on managing that particular property, even if you haven't quite dealt with the rest of your estate plan just yet. I wouldn't want to see someone delay on a good co-ownership agreement and then see all these problems arise with that property just because they're concerned that maybe they haven't done this other stuff yet, and they're concerned about how they overlap together.
Looking at what we're talking about here today, like with these families, what is the best route forward for a family to come up with a successful multi-generational project?
Jake, like the first thing I think of is open, honest communications, right? Like often, if once a family or group of folks that are getting together, once they can talk honestly about what their concerns are about the property, how they want to deal with certain things, how they want to manage things, and what they really want out of the property, it gets them a good chunk of the way to smooth, hassle-free ownership and governance of that property. And so in my world, when I see folks tell me that, yep, they've got a document that really approaches their particular situation, and that gives them a sense that they now have something that they can get behind, that they can work with, that they understand, and it reflects their honest and open ideas about what they want, that to me is success. First off, let me say I think that this is a really exciting time. I think that um, one of the reasons that we touched on with densification legislation that is fueling the current drive, um, although that launched in a landscape where we didn't have a good structure of how to manage these things, what opportunity that has presented is that people who are looking at collectively owning a piece of real estate have the opportunity now to design it for themselves. And so by with that opportunity, they can talk about what they need, and we can really get some excellent bespoke property, living, estate planning situations that maybe 10 years ago we didn't think we could. We didn't have the densification mandate. So, for example, 10 years ago, as you'd suggested earlier, like it was hard to even get approvals on laneway housing. It was hard to get approvals on a lot of things that now you can get approvals on. And I think that presents a really exciting opportunity for families. It presents an exciting opportunity for investors and for younger folks who are looking for opportunities to get into the market. And it also, as we learn and share more information about it, and you know, thanks to you guys for really spearheading a lot of that small housing build initiative and sharing videos like this, by getting the word out that these things are possible and that, you know, we have the expertise to help people manage these things really effectively, it allows them to take advantage of these opportunities in ways that we couldn't have done before. And I'm just really excited about that. I think it really opens some excellent doors that weren't open before.
Yeah, I mean, I couldn't agree with you more on so many points. That's
Yeah.
the part that I'm so excited, and I'm glad that we're working with firms like yours, that we're able to kind of find a legal mechanism that allows that to move forward in a way. Because as much as I enjoy a lot of the new build of housing forms, we can't lose sight that if we just get more housing on the properties that we have and not have to change ownership in that speculative manner, it's such an easy route forward to start to get some more attainable housing out in the marketplace. And for us, that's the big driver at Smallworks, is to have that as our end goal. And you know, working with groups of people coming together, families, is a great vehicle to do that. And working with firms like yours has been in fact, only working with your firm has been indispensable in us being able to move that forward. So I really appreciate the time you spent with us today. I'm sure there'll be other conversations and questions that will come back out of this broadcast, but we're really looking forward to continuing to move this dialogue and this activity.
Oh, that's great. And
Forward.
thank you,
So
Jake,
thank you very
and
much.
thanks for the opportunity to come and speak with you about it. And I'm happy to answer any questions that you guys might have at any point in the future.